Hi, my name is Sharma. I'm a partner at Sharma, Calgary's largest immigration law firm. Today I'll be discussing medical inadmissibility. Individuals seeking admission to this country are sometimes faced with the finding that they're medically inadmissible to Canada. The question arises as to what constitutes medical inadmissibility. What diseases or conditions will give rise to a finding of medical inadmissibility? The most common ground for a finding of medical inadmissibility is called excessive demand. In essence, CIC, or Citizenship and Immigration Canada, will compare your anticipated or expected cost to the Canadian healthcare or social benefits regime by comparing it to the per capita cost of a Canadian. And this amounts to a little over $5,100 a year. Many diseases, including diabetes, heart disease, HIV, or hepatitis C, will give rise to a finding of excessive demand. If you're an applicant for permanent residence under an economic class, and you or your accompanying dependent is found to have a condition that gives rise to excessive demand, you will be given an opportunity to respond to the visa officer's concerns. This is called the fairness letter. You have about 60 days to rebut the findings of the visa officer. It's very, very important that you gather the necessary and relevant evidence to deal with the findings of the visa officer. This may include a second opinion from another specialist. This may include evidence as to the cost of the health condition in Canada. There's extensive case law and jurisprudence relating to medical inadmissibility. This is a complex area in immigration law. I would strongly suggest that you contact experienced counsel if you are faced with the finding of excessive demand or medical inadmissibility. If the officer is not satisfied with your response to the fairness letter, he or she will find you medically inadmissible to Canada. Now, if you're an applicant under an economic class and you or your dependent have been found medically inadmissible, your only recourse to such a finding is to seek judicial review at the federal court. This again is complex and difficult and usually is undertaken with the assistance of experienced counsel. If you're a member of the family class, that is, you're a parent or grandparent of a Canadian sponsor, you have one more avenue of recourse. Your sponsor can appeal the visa officer's finding of medical inadmissibility to the Immigration Appeal Division. The Immigration Appeal Division is a tribunal here in Canada, and the IAD can consider humanitarian and compassionate considerations in deciding to allow the appeal. The discretion of the Immigration Appeal Division is quite broad. The IAD can consider factors such as the establishment of the sponsor in Canada. The IAD can consider ties that the applicants have in their country of origin, and of course the availability of medical treatment options there. Remember, there is no medical inadmissibility if you are being sponsored as a spouse or a dependent child of a Canadian sponsor. The lawyers at Sharma have extensive experience in dealing with medical inadmissibility and medical inadmissibility appeals. Call us today if you have any questions regarding this or any other issue in immigration law. Thank you.